Hey there, Legal Eagles. Welcome back to the Legal Palette, where we break down complex legal concepts into simple, fun bites.
Volenti non fit injuria. Now, what does it mean? Well, it's a Latin maxim that translates to a willing person. No injury is done. But what does that actually mean in legal terms? Essentially, it means that if someone consents to a risk, they can't later claim they've been wronged by that risk. Imagine this. You're super excited to go skydiving. You sign a waiver that clearly outlines the risks involved, like, hey, you might get hurt, or worse. Now, if you jump out of that plane and twist your ankle on landing, you can't turn around and sue the skydiving company. Why? Because you knew the risks and agreed to them. That's volenti non fit injuria in action.
But wait, where does this principle apply? You'll find volenti non fit injuria in various areas of law, especially in tort law. It's often used as a defense in cases involving personal injury, sports injuries, or even certain contract disputes. In sports, for example, players know they're at risk of getting hurt. They voluntarily accept this risk when they step onto the field. So, if a football player gets tackled and breaks a leg, they can't sue the other player for assault. They accept it.
Now, you might be thinking, does this mean people can never sue if they get hurt after agreeing to something? Not exactly. There are limitations to volenti non fit injuria.
1. Coercion or duress. Example, if someone is forced or pressured into consenting to a dangerous activity under threat or coercion, their consent is not considered valid. For instance, if someone is threatened with harm unless they participate in a risky stunt, the principle does not apply because their consent wasn't freely given.
2. Lack of informed consent. Example, consent must be fully informed. If a person agrees to a medical procedure without being told of significant risks, and then suffers harm as a result of one of those risks, they may still have a legal claim. For instance, if a doctor fails to disclose that a surgery could result in a serious side effect, the patient's consent might not shield the doctor from liability.
3. Negligence beyond accepted risk. Example, even if someone consents to a risky activity, the other party must still adhere to a reasonable standard of care. If negligence goes beyond the risk the person consented to, the principle does not protect the negligent party. For instance, if someone consents to a car race, but the organizer fails to ensure that safety protocols are followed, leading to an avoidable accident, the injured party might still have a claim. 4. Fraud or misrepresentation. Example, if consent is obtained through fraud or misrepresentation, it is not valid. For example, if someone consents to a business deal based on false information provided by the other party and later suffers a loss as a result, volenti non fit injuria would not apply because the consent was based on deception. 5. Illegality. Example, if the activity is illegal, consent may not be a valid defense. For instance, if two people consent to a street fight and one is seriously injured, the injured party may still have a claim despite consenting because the activity itself was illegal. These exceptions highlight that while volenti non fit injuria is a strong defense, it doesn't apply in situations where consent is compromised or where the risk goes beyond what was agreed upon.
Here is a case law that illustrates the application and limitation of the principle. Smith versus Charles Baker & Sons, 1891. Summary. This case involved a worker who was injured by a falling stone while working on a construction site. The employer argued that the worker had consented to the risk by continuing to work under dangerous conditions. Outcome. The court ruled in favor of the worker, stating that mere continuation in employment does not amount to consent to unnecessary risks, especially if the worker had no reasonable alternative. The principle of volenti non fit injuria did not apply because the worker did not voluntarily accept the specific risk of injury without protest. Significance. This case illustrates that consent must be explicit and informed, especially in employment settings where workers might feel compelled to accept risks due to economic pressure.
So, to wrap it up, volenti non fit injuria is a fundamental concept in law that protects those who willingly accept risks. But remember, it's not absolute, and there are important exceptions. If you found this video helpful, make sure to hit that like button, subscribe for more legal insights, and ring the bell so you never miss an update. Drop a comment if you have any questions or topics you'd like us to cover next. Thanks for watching and see you in the next one.